In a 7-2 decision, the Supreme Court ruled in favor of the owner of Masterpiece Cake Shop and his case regarding his refusal to make a wedding cake for a gay couple in 2012. The decision centered on the Colorado Civil Rights Commission, commenting that the commission treated Jack Phillips unfairly. The decision referenced quotes from a member of the commission that the court ruled were unfairly hostile toward his religious beliefs. Patty, legal experts were quick to point out that this was more about the commission than religious freedom, but it's still the Supreme Court. So what did you think?
Well, speaking of backflips, the Supreme Court went out of its way not to really deal with the basic law in this case, but instead to focus on the Colorado Civil Rights Commission, which gave them ample opportunity to find fault with how the Colorado Civil Rights Commission had behaved in this case. You really should not be making any kind of anti-religious statements if you are a commissioner. So they gave the Supreme Court an easy out, which took it. We have a decision that looks like it's in Jack Phillips' favor, but it really doesn't get into the whole business of whether or not a business can refuse to offer a service that is protected to a group that's protected under the law. We don't have a decision on that. And I think it's very narrow. People are saying it's really broad. It isn't. It's a very narrow decision. Even the people who are organizing Pride Fest, Lonnie Hansen, who created the Great Equality Cake 3 years ago and is doing another thing this year, he goes, it's a step back, but it is not one of the big steps. This is not sending gays back into the closet.
Krista, what did you think of the decision? I mean, when I hear about, and I agree with Patty, it's a narrow decision, but it's still the Supreme Court of the United States. A narrow decision is still a big decision. It's going to have some sort of precedence. We're going to see other decisions across the United States base it on this. What was your takeaway from seeing the 7-2 decision?
Well, you know, as you said, it's still a Supreme Court decision. It still has weight, even though it's a narrow ruling. It's also the subject of my Denver Post column today. And I think the point is this: you don't have to agree with the Bible. You don't have to agree with the tenets of any religion. You can disagree with the way those tenets are lived out. But what you cannot do if you are a government body is to show hostility to those beliefs. And so what I ended up doing, I ended up researching the First Amendment a bit and found out that Madison, when he was young, had run into some pastors who had been jailed because they were Baptist, and it was a dominant Anglican state of Virginia. And after that, he became inspired to take up the cause of religious liberty. Of course, he went on to then pen the First Amendment. And his point basically is that when a majority believes one thing, you still have to protect the minority. You still have to protect minority religions. And in this case, the country's gotten more secular, particularly with social norms, sexual norms. I think we still have to protect those who are biblically minded Christians to practice their religion. I think that the court may end up leaning in that direction. It's certainly my hope.
I think David Culp will be very proud that you were able to quote James Madison and you're taking this. Well done, Krista. Ben, what do you think about the politics of this? Because there's the legal decisions and what can happen in future court appeals, and that's going to have ramifications, but that's going to be a while from now. Do you think that there's going to be some political hay being made out of this, especially since we're in a pretty heated 2018 election?
Yes, I do. I think that both sides immediately claimed victory after the ruling, and I think that over time you'll see that the progressive side of the spectrum is probably going to be able to leverage this further by saying, you know, using it as an example of how our rights and liberties are imperiled and how folks that are minorities need to continue to be fervent in advocating for protection and equal treatment under the law. So I think absolutely it will be used politically, and I think you'll be hearing quite a bit about it all the way through November.
Justine, I'll follow up with you. Do you think this will be effective with bases, both conservative and progressive, about this getting the vote out in an important election year?
Well, I mean, we always hope that there's an issue that rallies people to get out the vote, but people usually don't show up, even with a case like this. But I think that this is a very interesting case for people to talk about, because the Baker won because the process was ultimately tainted here in Colorado. So looking at how we approach these type of cases in the future, and we all know that this turned into a huge issue for the legislature during the session this year with the Civil Rights Commission being defunded. So, I mean, this is one of those issues that I think that it will bring up the conversation for us to rally around. But also, through this decision, I mean, the process was tainted, but ultimately the accommodation law still stands. So now we need to go forward and talk about how this really sets out when it comes to discriminating certain groups.